Hello, good afternoon, and happy Sunday, everybody. Hi, Queen Olive, and hi, Karina. Good to see you guys here. We're going to have a great time today. I'm telling you. Everything okay with the sound? I hope so. If not, let me know. We're going to have a great time. I was thinking about the trial and where we are at this time, right? So, we are discussing the Karen Reed retrial 2025. If you are new to the channel and if you enjoy the content, please don't forget to subscribe, like, leave a comment. Help me to be able to help the algorithm to suggest more of our videos here to other people. And if you're coming back, welcome back. If you're watching it later, welcome. I hope you enjoy this content because I did spend some time creating this for you guys today to bring a new perspective. Okay. So the Commonwealth has just rested their case. They finished everything. They said, here is the proof that Karen Reed did this. And here is all we have beyond a reasonable doubt. Now, the defense has started on Friday to present their case. And we were all a little shocked at the end of the day when the defense is like, we don't want to call Michael Proctor judge. We just want to introduce his text messages through somebody else. Now, who is Michael Proctor, you ask? Well, if you're new to this case, buckle up because we are in for a ride. But if you're already familiar with everything, you know who I'm talking about, right? Michael Proctor is the lead investigator in the case. He was fired for his performance on this case. He was extremely unprofessional. We're going to hear from him, the man himself, today, because he did testify last year. But now the defense is thinking, we don't want to call him. This is our strategy, sure. And we're going to talk about both sides. And I just want to clear before I even start this video today, okay? I am definitely voting not guilty if I'm in the jury. Karen Reed is not guilty. There's so many reasons. We're going to go through it all. But I also want to help, if I can. I want to help bring light, maybe to the defense, maybe to the people who are only thinking one way. I want to bring light today because if you are in that jury and you're thinking, there's a lot of evidence against her, I'm voting guilty. That's who we are directing this video to today. I want to talk to the people who think they would vote guilty. Because for us, usually the people who are already voting not guilty, we have been watching similar channels since last year. We have been listening to the same people. We have been talking about the evidence the same way. But we have to realize, and the defense has to be very cognizant of the fact that there are people that are against the not guilty verdict. And I hope we can clarify some of the things. So, one of the things that I did ask on Twitter this week, which I was very happy about because you guys did respond and participate, and that is great, is this. I asked, please tell me, why wouldn't the defense, oh, that's not the right screen. Hold on. Why wouldn't the defense call Michael Proctor? Okay. And I just want to go over a few of the answers because they make sense. I agree with the answers. But then I'm going to give you guys the other side of why I think the defense. You guys know I love human behavior. I love psychology. So I'm going to talk about the psychology of the jury. I'm going to talk about the way humans make decisions. Okay. So let's take a look at the X real quick. So please tell me why the defense wouldn't want to call Michael Proctor. Here we have Anders who responded. Number one, honestly, they don't need to. They got it out. He's fired over conduct. They trust just evidence. Number two, whoever calls him is a disadvantage because direct exam, only cross. Sure. Let me see who else. Amber, it opens up Hank to be able to ask leading questions and testify to things he couldn't on direct. Cross has a lot more leeway, correct. Lexi, the law nerd. Yannetti said so Hank can lead and basically lay out his whole closing statement. Great. Where not Lemon said because the damage is done to the Commonwealth case by his actions and firing, which they can articulate to the jury without calling him. It's law 101. Thanks. Hello, awesome said, I was annoyed too, but doesn't it look worse that the prosecution didn't call Proctor? The jury doesn't know the defense can do it, so they bring in his buddies and get his texts that way. If Hank goes all in on innocent witnesses, he'll look like a fool. So yeah, I understand. I agree. I think that these answers make complete sense to someone like me because I'm voting not guilty. I'm in the jury thinking, I want to hear more from the defense. I don't like this guy. I don't like this prosecutor. I don't trust him. I don't trust his witnesses. They're all combative. They all seem like they're hiding something. But I'm not talking to myself. I'm talking to the people who are against Karen Reed right now in the jury. So I understand the prospect of direct examination versus cross examination. In direct examination, you have to ask simple questions, such as you cannot ask leading questions. You have to say, and then what happened? And then what did you do? And what was the next step? And then what happened? In cross examination, you can say, sir, you are a piece of beep, right? Correct? Didn't you say this because you're an ass face, right? You can lead the witness. So if I was in the defense team, okay, I would say, call Michael Proctor and have him read the text messages, and I would keep it very limited. I would say, do you recognize this paper? Yes. What is this paper? What is the date? What are the names? Please read the first sentence. What next? What next? What next? What next? Thank you. Have a great day. Or maybe I would say, are you still employed? What was the reason for your firing? And that's it. So cross examination would be limited to that direct examination. And then we're going to go over why, the psychological reasons why I'm still definitely calling Michael Proctor if I'm here. So I want to say hi to everybody. Hi, Karina. Mark. Hey, Sunshine Queen. Hello, Mark. Clerk of the Year, dishonorably discharged Chip. Marsha, happy Sunday. Awesome. Karina, shame nobody told Hank about not leading the witness. Hank is a disgrace, right? He just does whatever he wants. He has no shame. He throws everything in the wall. He doesn't care about the rules. And you know what? The judge doesn't correct him. So I understand why. Why he wouldn't care about the rules. So let's go back to the beginning here on the PowerPoint or Canva presentation, really, not a PowerPoint anymore, guys. PowerPoint is like outdated nowadays. So reason number one is going to be emotions versus logic. This is a psychological evaluation, okay, of how human beings process and make decisions. Emotional cues heavily influence human decisions, often driving choices even when they appear illogical. While logic and rational thoughts are important, emotions play a significant role in how we perceive situations, how we make judgments, and how we choose our actions. So, if we're the defense team and we are here to try to help the defense team, we have to think about the jury and what are they feeling right now? What is the impression? What is the emotional state the Commonwealth has left them in? Okay. We cannot think about everything we know about the defense. We cannot think about Brian Albert, Colin Albert. We cannot think about any of those people because they're not even introduced yet. If we are the defense, we have to think about what is the emotional state that the jury is in and what can I do? Sorry about that. What is the emotional state that the jury is in right now and what can I do as the defense team to bring the emotional state in favor of my clients? Okay. So then the second point, let me just see here. Okay. This is a quote from this book called Professor Everywhere. There is never a true cognitive assessment. Human rationality is a lie. The emotional side precedes and ultimately guides it. So let me ask you, if somebody in the jury is like, I don't care about these guys, I don't care about the ARCA guys, I don't care. All I care about is that she said I hit him. I heard her in the video say something like, oh, maybe I hit him, maybe I clipped him in the knee, and I think she's guilty. What this is saying is that logic goes to the side when you have that strong emotional feeling, and then the emotional precedes, it goes before the logical, before the rationale. We're driven purely by emotional cues, and my supposed rationality is made up after the facts. All human decisions are fundamentally emotional. Reason and rationality are the lies we tell ourselves to feel comfortable with them. To feel comfortable with them. I like to call myself a very objective person, okay? And I will give you an example just so you understand what I'm talking about. So I was watching the trial and I was watching Hank Brennan cross-examine the last expert, uh, Dr. Dusogra. Yes, Data Daddy. Data Daddy was on the stand, and Hank Brennan is saying, weren't you wrong? Wrong. And he was like emphasizing that word wrong like several times. And I was thinking, what a douchebag. Why is he talking to this beautiful guy, so smart and polite like this? Right. And then later I was watching another channel and I saw Alessi say the same thing to Dr. Welcher. He was like, wrong. And I did not even notice when that happened. I was like, oh, Alessi is beautiful. Everything he says is perfect. It's fine. He's wonderful, very smart. So that's just an example. Like when the defense does it, I don't even realize it. It just goes like I don't notice. But when the prosecution does, because I don't like them, I'm thinking, look at this. This is absolutely unacceptable. So it's just a little example, okay, of what we're talking about. So yes, Mark saying confused jury. Yeah, all of these emotions and all of these data it can be very confusing for some people. And Mark is saying Bev lets him do it. Correct. And another thing as well is that I forgot what I was going to say just now. Okay, so anyways, let's go to this next slide. So I want to ask you to be as objective as you can. Oh, okay, what I was going to say is that another thing I asked on X these past few days was how fast did you understand the data? How fast did you understand the data that the experts explained about the car, the timing, and everything? And 76% of people said, I only understood after I heard an attorney explain. 15% said, I understood it immediately. And 7% said, only after rewatching it. So we are hearing everybody explain, this is what this means, this is what this means, this is what the reverse, this is what the mileage means. This is what these experts are talking about. We all understand after watching people talk about and make comments on it. But if you're sitting there as the jury and just watching the presentation, well, this is 1.666, and this is this, and this is that, and that's plus minus this, and that's 22 seconds, and that's 35 seconds. I don't understand. I didn't understand at first. And I'm like, okay, maybe I'm very stupid in this aspects of, physics and science and math. It's not my forte. To be honest, I like psychology, I like reading, I like language. But I'm thinking maybe there's a person there in the jury that doesn't understand everything that they are saying. I would have liked it to be more clear. This means the car was on. This means this time this car was here, and that's how we came up with the situation. But that's, I guess, what they did do, what they did say, but I didn't get it right away. So it makes me confused, right? Clerk of the Year says we rationalize it as different because we perceive Alessi being right about him being wrong. But we hear Hank, if I lied, are you wrong? And we're like, ew, Hank, gross, Very true. Experts are a wash to the jury. I love this point that Mark made the other day, and he's saying here, that makes sense to me, especially as we're going to discuss the emotional aspect of the jury here. It makes sense that experts can be a wash For us, we have been discussing this case for a while. We're like, no, I believe what Archer is saying. I don't believe what Dr. Welch is saying. But for the jury sitting there and be like, oh, da 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 da, you say this, you say that, forget it. I'm just gonna think about what I watched, what emotions I got from the videos, and the fact that there was a tail light there, or there wasn't, or there couldn't be, etc. Okay. Karina says the data went straight over my head. My ADHD didn't like it. Thank you. Thank you. That makes me feel so much better because I was like this. I watched it, I rewatched it, and I think that only today, no, yesterday, I was watching the Friday Frenzy with Rob and Ian Runkle, and that helped me. That was very helpful because they did it slow and the PowerPoints, and I stopped and I read it and I thought about it, I read it again. I was like, oh, okay, I think I see what they're saying. But that was after I watched it like 3 times. So I'm glad that I wasn't the only one. So what I want to go back to is ask us, ask us to be as objective as possible and just tell me how you feel. Not how we feel, but what are emotions that you believe the Commonwealth was seeking to produce in the jury when they played this video, the first video. So I'm going to play this video and I want to say, if you don't know anything about the case, how do you think you would feel to hear this?
He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
His body was completely covered, but his head was completely covered. So I started to dig around his face and his eyes, and his left eye was fine, but his right eye looked like it was huge, like he had something happen to it.
There were...
Okay, we're going to stop right here because I don't want to really show that a lot. So when Karen Reed is on video, right? They're sitting there, the defendant is sitting there. They can't say anything to the defendant. They want to know what happened. We're curious beings as we are, and we're like, we want to know. We all want to know what happened. We're all trying to figure it out. We all want to know what happened. We weren't there. We don't really know what happened, right? We have our ideas of what happened, but we don't know for sure. And the jury's sitting there curious. They want to know what happened. And then we have the defendant, which is a huge mistake, in my opinion. I love the defense. I'm pro-defense. But huge mistake to have Karen Reed do these interviews before the case was resolved, as they probably think so as well by this time. And for nobody to like even give her the guidance of how to talk, because I don't think she's being malicious or she's trying to hide a crime. But when you hear that he did not seem mortally wounded, for the jury, it's like a shock. And before you guys say anything, okay, I understand the videos are out of context. So here are my key points to respond. I understand that no, the Commonwealth has not proven the charges beyond a reasonable doubt. I understand that yes, in a perfect world, no jury should convict her. Yes, Brian Albert and Brian Higgins are sus AF. Yes, Jennifer McCabe is not credible. Yes, the ME found the cause of death to be undetermined and no injuries to the lower extremities, which is very important. Yes, ARCA will show how there is no physical way this collision could have happened. But remember, guys, we are already convinced. We're talking about emotions, not logic. How do you think? Tell me an emotion. If you can think of an emotion that would have been produced in the jury after watching this video we just watched. Tell me something. Shock, questionable, curiosity. What do you think the Commonwealth would have produced or tried to produce emotionally by showing this first video? Okay, so let me know what you guys think, because it's very important that we're trying to be objective. I'm trying to help. I am trying to help. I'm just saying, in a perfect world, yes, we would all be not guilty. But remember, there are people that are not thinking that way. So this is why I'm trying to address this, so that maybe we can think twice. Okay, this is what we need to go forward. We need to actually produce some emotions to this jury. So Karina says confusing. confusing. Marsha, same thing, confused, curious to know more. Like, why is she saying that? Why would the defendant be saying that? Hello, awesome, evoke emotional without context. Absolutely, it is without context. I know Karen Reed meant the next day in the morning when she saw him. I know that she didn't mean after I hit him, he didn't look mortally wounded, so I left. I understand that. I'm with you guys. But I'm saying for the person who keeps using this as a reason to convict her, what emotions are produced? Because that's where the defense has to attack. The defense has to be very aware of the emotional portion of the jury decision making process and how crucial that is, because the defense is so smart. And we got Alessi, we got Alan Jackson, Yannetti. They're attorney Little, and they are extremely smart attorneys. They talk about this evidence like it's they are 5 years old talking about a party. They have no problem with that. But for the people who are sitting there, like the physics, the calculations, they're not black and white. They might rely on their emotions more. Modine says, but put Proctor on the stand. He loves women and performed a great investigation. I agree. Put Proctor on the stand because his face, his demeanor will produce emotions in the jury and it will help Karen Reed. Mark says, I think the jury would want more. Sure, that little clip was nothing. Absolutely, the jury would want more. So let me see where we go from here. Let me see if this is the same slide. He didn't look mortally wounded. No, this is a second one. So again, this is the last video of the prosecution case. So you guys already know. But again, what are the emotions? What are the emotions they're trying to produce with this?
So I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. Did he come and hit the back of my car and I hit him in the knee and he's drunk and passed out and asphyxiated or something? And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over? Or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability.
Okay. Fantastic. And here is Sheila saying she was trying to figure out a traumatic event. Finding John O'Keefe that morning. How is he here wooded by the road, in the front lawn where she dropped him off? Right. So Karen Reed is trying to figure out what could have happened. Like how did this happen? What could have happened? We're all curious. It's human nature to try to figure out. And even a friend of mine pointed out that when she saw this, when she saw Karen Reed saying, oh, could I have done this or hitting him? That's how she thought. She was like, wow, she's so innocent that she's trying to figure out what could have happened. She's even to the point that she's putting herself into the equation. Could I have done something? Because when you're innocent, you're just trying to find out what happened. If you're really guilty, you're not going to be like, maybe I hit him. You're not going to suggest that because you're going to know you're guilty and you're trying to hide it. So for us, yes, we understand. We understand she's trying to rationalize. Okay. Mark says everything she's saying is a question. And then Karina, Turtle Boy said in last night's show that the defense plans to play some of those clips in full context. Good. Marsha, I feel she doesn't know what happened either. Yes, I agree. I agree with you guys 100%. But I want to show you guys, and this is, just bear with me. We're going to go to Proctor shortly after, right after this portion. Just bear with me because I want to show you guys what I'm talking about the emotional state and how people make decisions. Okay. So this is these are some of the comments that video got. The video from the last video the prosecution played in this channel, not my channel, in this channel, and I'll tell you guys what it is. This is NBC. Okay, so here's some of the comments. Katie Cat said, the defense made complete ace out of themselves. I cannot believe how many people are defending this woman who could care less about all the trouble she has caused. I am so glad she did those interviews so the prosecutor could use her own words against her. That's what she sees. Michelle says, well, it has been done. How embarrassing. Okay, so that's a positive one for the defense. They have without been okay. Somebody else says, well, with all the evidence, the verdict is in. So that's, against Beverly. Somebody else said, if she broke her tail light backing into his car, why wasn't there one piece of her tail light found by his car? She either hit him on purpose or she hit him by accident, but she definitely hit him. Do you understand the cognitive dissonance of these comments? The person saying, how could she have hit him if there wasn't a tail light found by the car? And then she said, but she definitely hit him. That's what the person said just now. And so on and so forth. Somebody says prosecution did a great job. She broke nothing, cracked. Okay, so some people are definitely still pro Karen Reed, but I wanted to show you guys this because there are people out there who are not. And I think the defense has to focus on those people and how to convince them so that we can get a not guilty verdict throughout the board. Nobody wants a mistrial. I don't want to have a third trial. I don't want to keep dragging this on because I think that it's a waste of resources for the state, for the people who live there. And it's a very, very difficult experience for the defendant and her family. It's going to cost more money. It's going to drain her emotionally, physically, spiritually, all of the things. So I think the defense has to be very aware of the other aspects besides the scientific data of how the jury makes that decision so that we can get a not guilty across the board. Now, why do I think that they should bring, what's his name? Michael Proctor. Why do I absolutely think they should bring Michael Proctor? So we're going to watch a little bit of Michael Proctor here. Let me just put the right slide in. Wait. That's very loud. And we're going to talk about, so here are we talked about the emotions that the Commonwealth is trying to produce. And
so if I could turn your...
Oh, wow. One second. And the reason why, one of the reasons why I think, the first reason I already said is emotions versus logic, right? And here's the power of emotional cues, implicit processing. Emotional cues like facial expressions can be processed unconsciously and impact our decisions, even when irrelevant to the task at hand. So this is what we talk about all the time here in this channel. No matter if we know anything about body language, about micro expressions, we know how we feel after we meet somebody, after we have an interaction with them. So that is how our brain processes subconsciously the facial expressions, the body language, the feeling, the gut feeling we have, right? Emotions are a cueing system. Emotions act as a system that directs attention and prepares us for action by triggering physiological changes. So once you get an emotional impact, an emotional opinion in your mind, it's very difficult to change that. So how do we feel after we watch Michael Proctor reading those text messages? How different is it for anybody to read them or the person who actually wrote them? So we're going to take a look at how he read them last time.
Sir, if I could turn your attention to the documents before you, do you recognize those?
I do. From all accounts, he didn't do anything wrong. She's a whack job. C-U-N-T.
Objection.
So don't spell it. You have to. So these are your words, Trooper Proctor?
Yes, Your Honor.
Go ahead and say them.
Cunt.
Whoa.
Yeah, she's a babe. Weird Fall River accent, though.
Whoa.
Though, no ass.
And sir, what is it
No
that you are
integrity.
referring to there, or why would you text that?
These were, from all accounts, he didn't do anything wrong. I'm talking about the homeowner, Mr. Albert. I had mentioned the compelling evidence against Ms. Reed at this point indicated that Mr. Albert had nothing to do with Mr. O'Keefe's death. The rest of the
And how does he know? How does he know for sure that Brian Albert had nothing to do with Mr. O'Keefe? He never questioned him. He never went into the house. He never investigated. He didn't get his phone records. How does he know? He's just blank statement, because that's how they testify in this trial. I'm saying this, and that's a fact because I said it. Nobody needs to prove anything. So anyways, let's keep watching the impact of Michael Proctor's own words from his mouth.
May we approach?
Sure.
I'm sure the owner of the house will receive some shit.
And you respond at 10:56 as well as 10:57, is that correct?
Correct.
And what is it that you respond?
My first response was nope. Homeowner is a Boston cop too.
Why don't you just read it, Mr. Lally, and tell us who you attribute it to?
Question is that chick a smoke? Again, 4146 question mark. I respond EH. I respond again, nutbag, as Chief would say. I also respond with she's got a leaky balloon knot, leaks poo.
Guys, this is good stuff. This is gold for the defense. This guy has to go there with his banana face. He's going to be even more humiliated now because he already looks like he's trying to dig a hole in the ground. And he's going to have to read those text messages. I understand the defense doesn't want Hank Brennan to just lead him through the closing argument. Too bad. They have to find a way, being the excellent attorneys that they are, to ask him direct examination questions. And this is a lot of what I have on this clip is direct examination, because all the attorneys asking, because Lally introduced the text messages through direct examination. Remember that last year? He introduced them through direct examination. What does it say? What did you respond? What is the next text message? From who? Direct examination. And keep the direct examination as short as possible. I know we loved having Michael Proctor in the stand for hours and hours and hours for our entertainment. But yes, the defense is in a delicate position. But is this gold or what? To watch somebody having to read these things. Modine is like, why don't we want a third case? If we don't have a third case, what will we have to do? We want 5 trials if possible, right? I do. I would love it for the channel. Would be great. But I'm saying, for the family, for Karen Reed, for the sake of others who are actually involved in this case, it wouldn't be good to keep dragging this. It would be better to just get a not guilty across the board. And that's why I'm emphasizing these points today. Albert's black eye says, if the accident happened in the street, how was there taillight pieces in the yard? Ha ha ha. Right. And those are logical questions. Very good on the logical. But what about the emotional juror? Okay. Josh and you, it's good to see you. I haven't seen you in a minute. It's great to see you. Happy Sunday, my friend. Hello, Bianca. You're looking slick today. All right. Thanks, I guess. I don't know what that slick means because I'm not from here. And sometimes it's hard for me to translate, but thank you. Mark says hitting John's car, pieces would be pushed into the taillight. Mo, I want the story to be spun so much that the 5th trial will include aliens did it. And that's kind of where we are at. What if anything happened to John O'Keefe? Josh and you, and Alexis was launched into space. That's right. Aliens and space. George, hi, George Washington. Good to see you here. Long time no see as well. So, ProHack says, sorry I'm late. Welcome. Good to see you. Good to see you. Short to the point. Exactly. That's my opinion. He should testify. Short to the point. I know Alan Jackson wants to destroy him and it was fun, but just get him to read these things he wrote with his own stupid face. Okay. He's disgusting. Correct. Correct, Karina. Mo says the leak is in. So anyways, let's see a little bit more of what we would get if the defense decided to call Michael Proctor? What are the emotions? I already have here in the chat, disgusting. Everybody that is on the jury, even if they are pro prosecution, when they hear that he called her a CUNT, that he wanted her to kill herself, that her butt situation, they would be like, "Oh, that's low. That's uncalled for. That's disgusting." And if they are kind of pro defense, they'll be like, "Oh, that's it. I'm done. I'm done. This guy was the lead. Oh, hell no. No, this guy did it. He did something. I don't trust him for 1 second." So I think call Michael
And what, if anything,
Proctor.
is that in reference to, sir?
Again, to Ms. Reed's some medical conditions there. Again, unprofessional comments I should not have made. That I'm not proud of.
You're not proud of it? You sure?
You
just
agreed
got
in your
caught.
group chat that you needed to, quote, make this cut and dry because another cop was involved. Those are your words, right?
Objection.
Where is this?
This was referred to in earlier text messages, group chats.
So is that right? Did you say that, sir?
I did text that. I don't know if it's in the exact context. But yes, those were my words.
Group chat.
Yes, that was in the group chat.
Your friends wrote this whole thing, in their words, stinks, correct?
Yes, I interpret that as a joke.
During the course of your investigation, your figures of speech include the following. Would you agree, Trooper Proctor, that you have dehumanized Karen Reed during the course of your investigation?
breathing.
With
It's so
comments
loud.
and words like this.
Objection.
I'll give you this one, Mr. Jackson.
Would you agree with that?
Did you
I would say based off
dehumanize
that
her?
language, yes.
And do you believe that Michael Proctor, his involvement in this case, taints the investigation? Tainted the investigation?
No.
After you received the photo, that's when you said, I'm, quote, funny, I'm going through his retarded client's phone. Is that right?
Objection.
All this, but not too many.
Sure. Is that correct? It's on the top of page
Yes, sir.
685.
That's correct.
And your Buchanan liked that comment. Funny, I'm going through his retarded client's phone. Didn't it? Not at all.
The investigation was done with honor, integrity, and all the evidence pointed in one direction only.
Honor
Who do you
and
hate the
integrity by
most?
Michael Proctor?
Was that a question? I'm sorry.
What, if any,
Okay. Who do you hate the most, Trooper Buchanan or Trooper Michael Proctor? I think that Buchanan has more like of a malicious side to him, like an arrogance, and Michael Proctor has more of like a not so smart side to him from my observations. But guys, this is priceless to have Michael Proctor, and I understand some of what I just showed was cross-examination, not all of it, not all of it. I showed a lot of direct examination, and that Alan Jackson wouldn't be able to ask him certain questions. But the feeling I got when I first watched it was what is reflected in this video. The fire, the person melting down, the guy just like trying to disappear and just being like ridiculously embarrassing. Because that's why I created the video like that when I did it last year. I was like, there's got to be like fire around him. He's having a meltdown because this is terrible for him. So I think that if the jury has the opportunity to watch Michael Proctor read his own text messages, it will produce an emotion that will be beneficial for the defense because it will produce suspicion. It won't make the arguments of the defense far-fetched. I understand that text messages can come through somebody else, but when we have an emotional connection to an information, our brains store that information differently than we just reading something. Let's talk about you read a book, or some people just really love books, but let's say you read a story and then you watch a story. You watch the emotions, the facial expressions, the tears. If it connects with us emotionally, it is stored deeper. And I cannot tell you the amount of significance that that would have on when they're making the decision, because a lot of people are going to make this decision emotionally. I'm telling you. I'm telling you. Okay. Marsha, I just started watching the trial this year. Wow. So you were the person that didn't watch the last time. I'm kidding. A lot of people didn't. I haven't had the time to watch previous testimony. The opening statement from Jackson about Proctor hooked me. See? That's a great example of somebody who heard about Michael Proctor and was like, "What is this? What did you just say to me?" Exactly. Mark, he said, pin it on the girl that has to come in. I think that the text messages are going to come in regardless. The thing is, how are they going to come in? Right? Joshing you, the prosecutor will downplay this by saying he was fired for this and not the investigation. Yeah, but I think he has to respond truthfully. What are the reasons for your, like, did you receive a letter of termination? What were the reasons listed? For example, that is a direct question. Scott McGinnis says the defense and prosecution are playing 3D chess. Who will or will not call Proctor? The defense knows biased Bev will not declare Proctor a hostile witness for the defense hiding their hand. Hiding their hand. Okay, I like that. I like the sound of that. If the defense has something in their hand that I don't know about, well, they have a lot because I haven't watched the freaking defense case. But about Proctor being called that we don't know about, I'm all for it because I trust the defense. I just think that if they really don't call him after the videos of Karen Reed, also that's not good. It's a mistake for me. But this is a great point. I would not, if I was the defense, expect the judge to declare him hostile because the judge does whatever she wants. No matter what the law says, she doesn't care. She doesn't care making the wrong decisions, being biased towards the prosecution, showing the defense her disdain for them. She doesn't care. So I would not count on, no matter what Proctor does, even if he punches Alan Jackson in the face, I would not count with the judge saying, okay, now he's a hostile witness. Go ahead and do the cross examination. Use the tools of cross examination. So I believe that for sure. So when I ask you guys, who do you hate the most? Corina says Proctor. Sheila P says Buchanan. Mark says lizard lips. There goes the body language. Lizard lips. That's right. Scott McGinnis, if bias Bev blocks the four witnesses and their chats with Proctor, the defense may be forced to call Proctor, a trap that Brennan wants the defense to step in. Brennan knows he has the judge's bias. I agree. And what a masterful move by Hank Brennan. I dislike the guy more than probably most people, but that was a masterful move. He's like, you know what? I'm going to play, I'm going to gamble, I'm going to throw this at the wall. I'm not going to call the lead investigator. If they want to call him, call him. Then I'll just lead him. I'll just lead away. And he has no shame in the leading. And he will lead even with things he's not supposed to say. He will imply the defense has to prove something. He will make so many implications. And yes, we don't want that. But I believe this defense team is strong and smart enough to conduct a direct examination that keeps it limited to what we want to be introduced. And they're strong enough to handle the cross. Marsha. I feel like I've been waiting to see evidence of the corruption in this case rather than a collusion. I haven't been disappointed so far. Now look at this. Marsha is her first time watching the trial. She has not watched last year's testimony. So her opinion is very important to us. It gives us a perspective of somebody who is just watching this trial and what are they thinking? Where's their mind going? And from the beginning, she's like, I'm waiting to see the corruption. So number one, the defense hasn't shown that enough yet. But number two, she hasn't been disappointed. So there is a level of corruption that she's satisfied with. Karina says, I don't think for 1 minute she's gonna let them in. Oh yeah, I don't think Beverly is gonna. We're so like intimate with the judge. We're like, oh Bev is not gonna let anything in. No, I agree with Karina 100%. I don't think the judge is going to let his friends come in to bring the text messages in. And what else was I gonna say? I don't know why I'm having like these memory blanks today, but I don't think that's gonna be allowed. Okay, if I remember later, I remember later. Oh, okay, I remember. Good. Okay. So when the guy was testifying on Friday, the Proctor's friend was testifying about the text messages. He said he doesn't remember the text messages, and I don't believe that for 1 second either. Because if you're part of that group text and after everything that happened, everybody knows about this group text in the whole world, you remember the text messages, sir. Are you lying to us because you don't want to testify, because you don't want to be the one to introduce these? You don't want to be famous? Is that what's happening? Because I don't believe that you don't remember them. And Hank Brennan saying, he said he doesn't remember. Never happened. Scott, Judge Beverly Cannoni owes her entire career to Michael Morrissey, her genesis, and she is loyal to her political party. She definitely shows a lot of bias, and we have made videos from her bias here in this channel. I have cut many little clips showing how she shows blatant disparate treatment. One way for the prosecution, one way for the defense. Joshing you, the direct answer is he was fired for conduct unbecoming, not botched investigation. Sure, that's fine. That's fine if that's the reason why he was fired. The people in the jury still will see the bias, even if he doesn't say I am biased, even if he doesn't say even if he says the investigation was conducted with the utmost integrity and honor, which he's gonna say if he comes in. That's like a script they have, him and Buchanan. The people still see him. They still see his demeanor. They still have the feeling connected to him. He's a real person that will admit to his words. He's not just somebody reading, oh, this is a text from some guy. You don't put a face to the person. It doesn't bring you the same emotional connection. Mark, defense has some surprising things coming in. I'm excited. Gotta keep in. No, I don't know why I read that way. Gatekeeping, Clerk of the Year 2027 CP. Gatekeeping. That's right. Gatekeeping is Beverly. She's just like a referee, That's coming in. That's not coming in. As long as it's for the prosecution, she allows anything. Scott, the judge gets to decide whether or not the witness is hostile. So bias Bev is the wild card. Not so wild because we all know what she's going to do. She's going to say he's not hostile and he can do whatever he wants. But I'll tell you something. When I watched Proctor testifying, the judge was kind of like, let him burn. No, go ahead, Jackson. Ask him that. I don't know what it is with Proctor, and I don't know if she changed it now, if her sponsors are telling her, no, you're going to have to do this way. But last year when he testified, she kind of let him burn a little bit. ProHack says, I dislike Jan McCabe the most. Josh and you, he will automatically be declared hostile witness if the defense has to call him. No, Josh and you, we don't agree. We don't think so because that would depend on the judge, and the judge is biased against the defense. So he should be a hostile witness, yes, because this is unfair that the prosecution is playing this game. I'm not going to call him. You call him so I can lead him. It's like almost unethical, but he's being allowed to do it. So we got to play by the rules. All right, so let me do a few more of this video and then I'll read your comments again and we'll go from there. Let's go, Michael Proctor. Show us your demeanor when you are reading these text messages. What emotions do you think his demeanor will produce in the jury?
Impact did that have as far as your investigation was concerned regarding this?
These juvenile, unprofessional comments have zero impact on the facts and the evidence and the integrity of this investigation. They said these are unprofessional comments, but they absolutely do not detract from the integrity of the investigation or the facts and evidence of it.
Your Honor, may I approach this retrieve?
Yes.
What are you referring to in that text, sir?
I'm referring to the arrest after Ms. Reed was indicted by the grand jury.
And again, as far as the terminology that you use in that text message to your wife, why is it?
Again, unprofessional messages I should not have sent. I don't have an explanation other than they're regrettable and something I'm not proud of, the language I used.
You literally said that you hope that Karen Reed, the subject of your investigation, the woman sitting to my left, about 7 feet from me, that she would just die, correct?
The figure of speech.
You wanted her to, the figure of speech is you wanted her to kill herself,
No,
right?
no, it's not. False accusations of being conflicted and corrupt spouted in an open court, which there's zero evidence of. Like I said, I stand by the integrity of this investigation as well as every trooper and supervisor in my office. I've never met any of them.
And at some point subsequent, did you have occasion to?
Julie and Chris Albert, I believe, were in the same room as us.
Now, with respect to,
They informed us that Miss Reed was released.
I'll allow it just as to where you went.
That Miss Reed was released several hours prior to our arrival.
and you mentioned there was a second reason, and that was to view Mr.
Only one piece of footwear.
Look at the guy shaking his
revealed the
head.
potential of a
The
vehicle
bottom
strike.
left.
Now, in addition to Sergeant Mechanic is one of your supervisors within the
Because they were
detective
like, Michael Proctor's like, well, we saw shoe, and that was evidence of a car collision. The shoe. And the guy's like, what? What is even, what
that
are you
correct?
saying?
Yes.
What, if anything, with regard to that, did you communicate to Lieutenant Tully?
Objection.
As to how it goes to the investigation,
Yes.
I'll allow it.
Sergeant Mechanic and I. Sergeant Mechanic and I.
And with respect to Detective Lieutenant Tully, are you aware that subsequently in the afternoon that there was a search that was conducted in the area of 34 Fairview Road where Mr. O'Keefe was found?
Yes.
And are you aware of what, if anything, was recovered in the area where Mr. O'Keefe was found on that day?
I'll allow it as to the investigation.
Now, from these items of clothing, I'm sorry, let me just let the siren move on. Trooper, in addition to the shoe that you've already referenced, what, if anything else, did you observe about what kind of clothing?
We take an item for evidence. We'll put it in a brown paper bag, document it, time, date, who secured that item, address, where it's discovered, and then we'll bring that back to our office, to the evidence processing area. From there, it'll go to a permanent evidence room.
Did either yourself or Sergeant Buchanan have any access? To
Why are you
that evidence source?
testifying?
No.
Why are you testifying, Lala?
Now, with reference to these items that were seized and
Okay, let me pause here because I want to read some of you guys, your comments. I want to read some of your comments. Karina says, I love those sirens every day. Yeah, and they come in sometimes in the best moments, like when Hank's trying to ask a question. The sirens are like, no, shut up. We can't stand you anymore. And he's like, shut up, Brennan. We don't want to hear it. We don't want to hear it. So Scott said here, the defense and prosecution. Oh, we already read this one. This is okay. Mark, I'm not a book smart, but I can read people. I'm not book smart, but I can read people. And that's right. A lot of people are like that. You know, you can read people. You understand the whole psychology of what's happening. You're like, I don't trust this guy, or I trust her. Like, I trust the medical examiner, the doctor. I'm like, yeah, she seems like very straightforward. Now, Buchanan, very arrogant, combative. I don't know. Jennifer McKeeb is always asking for the reports. I don't know about these people. Josh and you says, if the defense has to call him, the defense may have to ask one question first, but all hostile witness means you can treat it like cross-ask leading questions. Right. The hostile witness, yes. So for people that don't know, right? I'll clarify a little bit of what I know. When you are an attorney and you are calling a witness, you can only ask them direct questions. You cannot lead them. You cannot say, and then you went to the building and you saw the body, right? No, you have to say, so what did you do next? And then what happened? And then what did you do? And then what did you see? And then what did you do next? That's the direct. Cross is better for most attorneys because they can just put the arguments they want to make in the question. You were biased because you texted about the defendant, correct? You did not conduct a proper investigation, correct? And you can just lead. So when the prosecution doesn't call the lead investigator, it means that defense, if they want, they have to call Michael Proctor, which means they would be limited to asking him direct questions. What did you see? What did you do? What is on the page? Who wrote this? What is the name? What does the next text message say? Direct questions. The defense doesn't want to do that because then Brennan would have the ability to cross, to ask leading questions all day. The process is not automatic though, Josh and you. They have to ask the judge permission to treat permission to treat the witness as a hostile witness. And the judge has to say, yes, permission granted. So when we have anything related to the judge and we have to depend on her making a decision, we cannot say it's guaranteed that they're going to allow this to happen. So if the defense decides to call Michael Proctor, they have to call him with a plan that they are only going to be able to ask him direct questions and keep it as limited as possible, just to have him read his words. Scott, either way, Proctor called or not, Proctor is the giant elephant in the room for the jury. All adds to the reasonable doubt pile. Yes, there's so much reasonable doubt. There is so much reasonable doubt. Kelly Cow says Proctor was probably even bad for her. For the judge, yes. The judge was like, all right, go ahead, Jackson. Didn't you say C-U-N-T? So what is the word? Tell us. Wasn't that your word? Go ahead, tell us. Bev is trying to force the defense to call Proctor. Definitely the prosecution is doing that. That's for sure. Clerk of the Year 2027, judge also scapegoated Proctor in her decision for the motion to dismiss. Maybe she doesn't like him. Maybe. Scott says true. Bev left Proctor to the wolves in trial 1, but this time she may want to help the prosecution by not declaring him hostile if the defense is forced to call him to the stand. I'm with you. I think this is where this is going. I don't think she is going to allow him to be treated as hostile because of whatever her reasons are. In a fair world, yes, but she does not rule a lot for the defense. Okay, so I wouldn't count on that. Kelly Cow says, and then you were fired. Correct. Okay, so then let me see here. The new ones, the new. Kelly Cow says you skipped the Stop and Shop step. Yeah, he said, we just put in a brown bag and then we label it. I'm like, sir, you put the solo cups in the Stop and Shop bag. We all know that. Mark, LOL, he was thinking, are they coming for me? The sirens. And the butcher paper step. Marsha is watching the trial for the first time. She did not watch the first trial. This is very, very interesting to me. I worry the jury might feel bad for him too, though. Like secondhand embarrassment. Also, he could cry and break down the stand. I wouldn't put it past this guy. I don't think he will cry because he's very like sociopathic. He did not display emotions on the first trial. I have a whole video that I did his body language last year. I'll plug it in here after. It was like an hour and a half or 2 hour video, and he did not show emotions. It would be very difficult for him to fake emotions. And I'm very empathetic. Usually I will feel bad for people. I'm like, oh, come on, don't go so hard on him. Oh, come on, poor guy. Like for Trooper Paul, I kind of felt bad for Trooper Paul a little bit. I was like, oh my God, this guy's like not getting anything correct. Stop it. It's making me feel bad. But with Proctor, I didn't have that reaction. So we don't know how people would feel. Do you feel bad for him, Marsha? We want to know. Pro Hack, I want this tool on the stand just to answer the question how he's currently employed. Well, this is a long story. I'm not. Exactly. Joshing you. Oh, Joshing you has some law for us. Statutory exception under Massachusetts GLC 233. If you're calling an adverse party for their agent, but there you go, it's not an adverse party or their agent, you may use the leading questions immediately without needing them declared hostile by the judge. Okay, let's look into this. I'm not going to say anything more because I don't know. But this is great. If they can do so, why would Yannetti say that they don't want to call him because Brennan would lead him through the whole closing statement? Modine says, I'd be a terrible witness. My answer is always, I don't know nothing about that. I don't recall. I don't know. Isaac K, leave me alone. Let me go. Scott, this defense team is great enough to direct exam Proctor well enough, even if biased Bev does not declare Proctor hostile. I agree. Mark says Bev won't do it. I agree. Scott says another frustrating aspect, all of Proctor's texts were FBI procured, and the jury can't know that either. All the texts were part of the federal something handed over before trial one. There he is. I was just thinking of you, Ask Bob. I was like, where's Ask Bob? We miss him. So very frustrating that a lot of the information is not introduced and the whole FBI involvement is not introduced. I feel like the jury should be able to have all the facts, and it's just very frustrating that one person, one human being has the ability to keep stuff in or out. Mo, did you drink from the solo cups by mistake? Marsha, that is very sweet. that she would have feel bad, right? But he doesn't deserve that. Calico is saying, I wish Bianca could do the closing argument. Kara would be acquitted. We're working on it, asked Bob, because you asked. I'm working on a mock closing argument. Mark says his ego won't let him feel bad. Exactly. He seems like kind of like some weird traits, no emotion traits. Proctor will also cry Turtle Boy. Witness intimidation angle will be brought in by Hanky Panky Brennan. Right. But nothing can deny your own words. Comes down to rebuttal. Kelly Cow, I'm a law student. An adverse party is in the opposite of the opposing party, not the witness. Judge does have to declare hostile, and he has to not cooperate for her to do that. That's what I think it is, too. I agree with you, but I'm not 100% sure. Adverse party, the lead investigator for the Commonwealth. But I think it's who calls the witness. That's what they're fighting about. Hoping Hanky opens the door to the FBI. He's fired now. Federal Tuhi, I don't know how to say that, is all disculpatory evidence handed over as a result of the DOJ investigation into DA Meatball Morris's office by the U.S. Attorney Josh Levy just before trial one. Yeah, they had a lot of stuff with the FBI, a lot of evidence that was turned into them that the jury will never know about. Okay, so let's just finish this clip here with more Michael Proctor.
Have any access to that evidence storage?
No.
Now, with reference to these items that were seized and say items that were seized,
No.
to these items that were seized and say items that were, did either yourself or Sergeant Buchanan have any access to that evidence?
Not
storage?
Buchanan.
Now, with reference to these items,
The snow is about up to our waist.
as you're walking up the driveway towards the home, you see Ms. Reed's vehicle, is that correct?
Yes.
Karen Reed, is that correct? Morning. What did you do?
I reached out to Ring several different times. They informed me if a video is deleted, there's no digital footprint of that. It's essentially kind of gone forever.
So the video is kind of gone forever. I Didn't really get any of the evidence. The video is gone forever. I found a shoe, and that's evidence of the collusion. Okay, so I want to go back to the part of the slide. I'll come back to this video. 9 minutes, 9 minutes. Let me see how much longer we have of this video because I want to go back to the reasons. Okay, we stopped at 9 minutes, so we can go back here. Hold on, hold on. Oh, there's a lot more. Okay, so I wanted to go to reason number 2. Reason number 2 why I believe the defense has to call Michael Proctor, and that is cognitive dissonance. Guys, I want to ask you this question, especially after COVID, okay? And this is by no means an invitation to do it here in the chat. Have you tried to talk to anybody that had a different opinion than you about COVID, about politics during that time? And were you able to convince them with your reasons, with your facts? That is what cognitive dissonance leads us to. Cognitive dissonance is when, despite the facts or despite a piece of information in front of you, your brain is unable to like process that, and it's just like two pieces of information fighting. You're like, I see this evidence, but this is my emotion, my feelings about this subject, and nothing's going to change that. Even though you keep showing me this, I still feel this way. Sure, that happened, but yes, this is my opinion. So it's two pieces of information that are contrary, fighting against each other in somebody's brain. And when they have a feeling, a strong emotional attachment to their opinion, it's almost impossible to convince them otherwise. So when the jury's sitting there and they have an emotional feeling that Karen Reed is guilty because of this or this and that, for somebody else to convince them in an emotional level that she's not guilty is almost impossible when they have that emotional conviction. So I do believe that bringing Proctor in and showing producing the emotions in this jury that Proctor will produce, the disgusting behavior, the lack of emotion, the terrible things he said, by him saying it, I think that will be very beneficial for the defense. I think they should call Michael Proctor. So this is cognitive dissonance is a state of mental discomfort experienced when holding conflicting beliefs or values, and it can significantly impact jury duty. Jurors may experience dissonance when their personal beliefs clash with the evidence presented, legal arguments, or the instructions given by the judge. This discomfort can lead to various cognitive strategies to reduce the dissonance, potentially influencing their decision making. So here we have 5 types of people that are in the jury deliberations that we could have, right? We have somebody here on the top left, an extroversion that can persuade others. They may be able to persuade others. They have the neuroticism. And that is somebody, let me see, I can't read it. Neurotic individuals may be prone to cognitive biases. So whatever he thinks it is from the beginning, nobody is going to change his mind. We have an agreeableness person, and they are going to be susceptible to conformity. They will probably change their opinion if needed, if a lot of people keep telling them. Conscientiousness. Now, this juror may be more thorough and reliable. They may want to consider all the facts. Openness to experience. Individuals with high openness may be less prejudiced. Okay. So we have different types of people. We have different types of people in the jury. We have different types of people in society. So this is a factor. And when we bring that emotional value to the jury, everybody's going to react. Everybody's going to feel it, no matter what their type of jury, no matter what type of juror they are. So here is some more on the cognitive dissonance with evidence and arguments. Jurors may experience dissonance when they are presented with evidence that contradicts their initial beliefs or assumptions about the case. This can lead to selective attention, where jurors focus on evidence that supports their preferred verdict and downplay or dismiss evidence that contradicts it. And a great example I gave to you today was I was outraged when I heard Brennan ask, cross examine Dr. DeSogra, "You were wrong." I was like, this is absolutely unacceptable. But then again, later I heard Alessi say the same words. Oh, so that would be wrong. And I was like, oh, I don't even remember that because I like Alessi. So this is my cognitive dissonance showing how I will downplay when is my side. And I will only have the selective attention to what I want to have selective attention to. For example, jurors who are initially biased towards the prosecution may distort evidence or arguments to maintain their belief in the defendant's guilt, even if the evidence is not strong. Example, last year, some of the jury members said they disregarded Arca's testimony. They were like, I don't know who those guys are. I thought they were insurance. I don't know what they were all about. I just disregarded that. So that is what I'm talking about. We are all in agreement. We are all aware of the amazing amount of reasonable doubt in this case. We are all voting not guilty. We cannot understand how people would be guilty in the leaning towards a guilty verdict, but we have to be aware these people exist, especially if we are in the defense team. We have to be aware of how we could talk to those people, because the people who agree with us, they don't need any convincing. They are on board. But the people who are in cognitive dissonance, who have that, they already heard from the prosecution, they prefer that story, and they're going to minimize the proof, the fact. So even though the proof is right in your face, they will minimize that. Okay. So let's see. Scott says, I have never been or ever will be allowed to serve on a jury for many reasons. My biggest one is a distrust the government always and forever. I will never get past the jury questionnaire. There you go. And if you're going to be honest about it, it's going to be like that. Honestly, I don't trust the justice system either, because we see in this trial alone how much injustice happens, how much biases, how many of the decisions are made just because people have an agenda, and it's not black and white. Not everybody's trying to do the right thing. So I don't. Ask Bob says Higgins must be called and explain the waterfall and CPD videos. Another one that I believe should come in is Higgins. Absolutely. We're gonna do a video on him another day, but absolutely Higgins should come in. Again, limited examination. Make him talk about the destroying the chip, destroying the phone, driving to the military base to do that. Show these people, give these people faces, give these people feelings, give the jury that experience. Scott says, haha, I don't see my personality type in that chart. Logical observer. Oh, this is interesting. Well, thank you, logical observer. I'm glad you're here. Yeah, this is a presentation I created to show reasons why we should consider, there are people there that don't agree with us. So let's consider them and see why, psychologically speaking, people may be locked into an opinion. And what can the defense do to change that? So if you got here later, go back to the beginning of the video later, because it's good stuff today. Marsha says, my twin sister thought Karen was guilty and got me to watch with her this time around. We have a base of respect and love, so we can listen to each other's points, but so far I'm not convinced. And is she still convinced? Is her opinion still that she would vote guilty? I would want to know that as well. But that's great that you guys can have conversations and talk, because it is so sad when people, especially members of family, have different opinions on whatever, religion, politics, and they just never talk to each other again. Let's just say, listen, this subject, let's not touch. Let's not touch the subject. Or if in your case, if you can have good conversations, respectable conversations, and listen to each other's point of view. Excellent. Most excellent. Um, Mark says, I don't try because I'm always right. LOL. Me too. I just think, oh, this person has cognitive dissonance. Obviously, they won't see my points, but I'm obviously correct. Scott, railroad, not the third rail. Haha. And Karina says, religion. Religion's another one. Yes. Ask Bob said, the grand jury system is broken and unfair. It's only used in the US and liberal. All developed countries eliminated it. It's unfair and easy to indict. This was a horrendous decision by the grand jury, who, by the way, didn't have all the correct information because people lied to the grand jury. Remember? Reports were changed after the grand jury didn't get to reanalyze the case. Carrie Roberts said she heard something, but she didn't. So the grand jury did not have accurate information either. Clerk of the Year says, Higgy, 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 you coming here? Oh, yes. Higgins is a disaster, and I don't think anything he said helped the prosecution. And he looks ridiculous on the stand. He looks like he's used to having some type of special treatment for being a federal agent because he doesn't have any fear of accountability. It's just, it would be good. It would be good. Prohack says, I really pray this jury is much smarter than the last one, or don't have cognitive dissonance, or don't have an opinion and they're locked in. They can be open-minded, watch all the evidence. We pray for that. But as the defense team, I know the defense doesn't have any obligation to prove anything, but if it was my life in the line, I would want everything to be done to help me. Anything. We have to put on a case, let's put on a case. We have to think of all the aspects, let's think of all the aspects. We have to convince the people that are voting not guilty right now. How can we reach these people? I wouldn't be like, you know what? The data speaks for itself. It's fine. They're going to see it. It's great, because that is not reality. It's what we would like to happen. Scott says 32 plus years in law enforcement bars. 32 plus years in law enforcement bars me always to just saying in all criminal trials anyways. Right. So thank you for your service, Scott. And you're saying you couldn't be a jury member. Glenn Lake, hi. Where were you? Taking a nap? Good afternoon, mister. Happy Sunday. Locked into an opinion, brain freeze. Exactly. Maybe they're having a brain freeze moment, and that is their opinion, and that they're not changing. Prohack says, thank you again for your service, Scott. My spouse is currently a CO. Karina says, hi, Glenn. Defense could eventually decide we have facts and logic. We need an emotional moral victory. Then calling Proctor last becomes a strong move. Right. You have the logic, or put something in the mind of the person who is doubting right now that Karen Reed is innocent, the person who's thinking, she's guilty, forget it, you don't need to tell me anything else. Put something in their mind to be open-minded, because if you talk about conspiracy and cops planting evidence, I believe that happens. I believe that happens more often than we know. But when you are face to face with a police officer in real life, you go outside and you see a police officer, I treat them with respect. I'm like, oh, hi, good afternoon. Thank you for your service. That's how I view authority. But when I'm home watching these videos, I'm like, oh, this cop is corrupt, obviously. So we have to take that into consideration, guys. Glenn Lake says, hi, Karina. I traded my cognitive dissonance for conspiracy theories. Hey, a good one is always good to go down into a rabbit hole, Brian and Brian waited for John in the garage. More probable than the car collusion. I am one that believe that all jurors are to be I can't say these words. Penultimate disrespecters of the government. A civilian juror is supposed to have their arms folded. Prove it to me, state. Prove it to me that my citizen peer did this. And I agree. Because, and I hate the fact that they overcharge people too. Like they pull somebody over for one thing and they're like, no, now it's this and this and this. It's not a misdemeanor, it's going to be a felony. And now you're resisting and this and this and that. Kelly Cow say lawyers always say the scariest thing is to have an innocent client so much on the line. Right, right. I really pray, Queen Olive, I really hope and pray this jury is smarter too. It is just common sense. Yeah. Marsha says, my sister was turned off when the Commonwealth changed their theory this time around and doesn't watch with me anymore. I think we've won. She's like, all right. I don't want to see this anymore. I don't like it anymore. Just leave me alone. Leave me alone. Okay, so now the reason number 3 that we're going to talk about why the defense should call Michael Proctor to the stand so we can see his stupid face reading his stupid text messages is confirmation bias, which we already heard Alessi talking about in this trial. So he knows what it is. He knows what it is. So jurors may selectively seek out and interpret information that confirms their existing beliefs while ignoring or discounting information that contradicts them. So one aspect of this is minimization. Jurors may downplay the importance of evidence or arguments that contradict their preferred verdict. So here are some examples. Somebody's like, oh, but she said I hit him. And then somebody else may say, well, the videos are out of context. Then somebody was like, oh, but they have a text saying the guy never went into the house. Why are they calling him the guy? Somebody might say, well, but her taillight is broken. He was dead. So that's what happened. Somebody else might say there was no collusion. And somebody said, well, but she said he did not look mortally wounded. How would she know that? So I'm just showing you guys that when you have an opinion and somebody else says, but this, you're like, but you minimize it. But that's that, like the videos. Oh, but Karen said in the video, could I have hit him? And then other people are saying she said I hit him. So she's saying I hit him. Why shouldn't I believe she said I hit him? And then the other juror may say no, but those videos were obviously out of context. We didn't hear everything she had to say. But the person who is taking that as face value, they're going to be very difficult to convince because they have minimization. They're going to take what they believe in and they're going to hold on to that. And whatever you say, maybe they hear, maybe they discard, like they disregarded Arca last time. They're like, but those people are weird. I don't want to believe them. So that is an example of confirmation bias. On another note, rationalization. Rationalization, the jurors may find justification for their decisions that are not based on the evidence or legal arguments. So here are some of the comments that I got from X. Okay. Somebody said, you hit him on the knee, go in reverse at 24 miles with your foot, the gas pedal 75% of the way. That seals murder 2 for me. Okay. So this person is not looking at anything else. She's not looking at the evidence the defense has provided so far. She's not looking that this 24 miles per hour could have happened when the SUV was being towed. She is just rationalizing, this is all the evidence I needed. I'm ready to convict. That's what she's saying. Somebody else was like, reminder, while we wait, Karen Reed says, I hit him, is factually guilty. So this person doesn't realize that the statement was, did I hit him? Maybe I hit him. Could I have hit him? Her rationalization is, this is what I have, and that's where I'm going with. Then we have other people that are pro-Karen Reed, They said they found Jennifer O'Keefe, rolled him over onto his back. The only way he could have gotten this kind of injury was to fall backwards. Free Karen Reed. The suspicious behavior of the McAlberts. It seems like they have something up, leaves too much reasonable doubt. So these are the people rationalizing their position. All of this is part of confirmation bias. Is how when we have an opinion, it's very difficult to change. And this brings us to this last one, changing beliefs. In some cases, the jurors may actively change their beliefs to align with the evidence or arguments, but this is less likely than using other dissonance reduction strategies. So I understand the attorneys have been working very hard in this case and they are very familiar with the evidence. And to them, it's very clear. And to most of you guys, the evidence is very clear. But I am talking about the people who are not seeing the way they are, and they have to remember, these people are going to be emotionally based. They're going to have cognitive dissonance. They're going to have confirmation bias. They're going to disregard some of the evidence we present. So how can we reach this jury? How can we reach the people who are feeling this way? And I believe that a strong way to reach this type of person in the jury is to introduce emotions, is to introduce these witnesses that show us emotionally how this case is so strange. Okay, so let me see what you guys are saying. I'm gonna go from the last one up because otherwise I get very, very lost. Glenn says, "Hey Danny, we seem to be on the same tour." Were you guys in the same channel earlier? Scott, mob lawyer Hank Brennan was hired by crime boss DA Meatball Morrissey for a reason. Brennan is running defense for the true third-party culprits and covering up the corrupt cops who framed Karen Reed. Marsha says, Bianca, do you think jurors choose a side at the beginning, opening, and then look for evidence that supports it while minimizing evidence that does not? I think that it is possible that some people do that, even though they will say no, because a lot of the things that we do happen subconsciously, and it's just the way the human brain works. Psychologically speaking, we may look at a defendant. It's very a common point that people make, attorneys make this point all the time. We look at the defendant and you say, well, they must be bad because they're sitting in the bad person's chair. They're sitting in the defendant chair. They must have done it. That is classic bias. So you're just sitting there already thinking, okay, how did they do it? Tell me how they did it. And we are primed to the negative as well. We're not primed to the positive. Our brains are primed to look for what's wrong and not for what's right. So a lot of people may sit at the jury in the beginning thinking, okay, I think she did it, but still be open-minded. So it's possible. It's possible. Ask Bob, something very evil is behind their obsession with convicting Karen Reed. We may never find out. And that is why I'm saying this video. If I was the defense team, I would do and I know they're doing their utmost best, but my opinion here is they should call these people to produce an emotional reaction to the jury, because we don't want this. We want her to be able to be not guilty across the board. Just not guilty, not guilty, not guilty verdict. We don't want a mistrial. We don't want them to be undecided. Glenn Lake, confirmation bias. Exactly. Don't forget to hit the like and subscribe. We've been here for an hour and a half, and I am very grateful that you guys are here. We're going to try to do this Sunday afternoon make this Sunday afternoon a thing. So I'm very glad that you guys are here. Let me see. Okay. Ask Bob says, Bowdy Ronnie made me nervous about any jury. A woman's life is on the line, and kept smiling and saying distractors. Mark says, happens every day. Yep. Kelly Cal say, yep, that was good. Logical observer, do you think the jury will be wondering where Proctor or Higgins are? I honestly don't think so. I don't think that these points that we are aware of are as strong on the mind of the jury as they are in our mind. Maybe Proctor, but Higgins, I don't think so. I think that's why I'm trying to bring this light into this video because the defense team has been in this bubble, in this echo chamber. We have been in an echo chamber, guys. News flash for you. We have been in an echo chamber, okay? You hear from the same people. You hear the information being emphasized, re-emphasized. And you agree with that information. And when people say, no, that information is not correct, you're like, reject, ignore, forget it. You are a lunatic. Forget you. How can you be so stupid? Right? So you have to understand that although the defense has this wonderful knowledge about this entire case as a whole, and we have a good knowledge of it, The jury is just experiencing for the first time. And they're like, okay, they talk about Proctor a lot. So maybe they would want it. But Higgins, it wasn't a lot. It is not clear. And that's why when I also talked about the closing arguments, I think it should be very clear, very simple, very easy to follow, and not so focused on the 1.16 point blah 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 plus RPM plus this plus that science talk. Okay. Um as Bob says, JFK assassination, 1963, and we still don't have justice. The government hid everything. Scott, the jury will be wondering where the heck Proctor and Higgins are, never minding the 12 other people or more that were in the house, including owner and cop Brian Albert. We are wondering that. We are wondering that. Is the jury wondering that yet? Clerk of the Year, Boston's finest. True Crime Social. Hi, good to see you and happy Sunday. Clerk Glenn, hey y'all. Mark says, if I'm a juror, I'm thinking, why is the Commonwealth not showing me the whole clip? Good. A lot of jurors may be feeling that way. Mob lawyer Hank. Okay, we already read this one. Okay, why am I reading everything again? Okay, I wanted to say on this one though, the obsession, the amount of money that the Commonwealth is spending with this case is insane. It's insane. Yes, yes. Thank you, Karina. I also want to tell you guys we have this wonderful Facebook group that Karina helped me create. She created for me. That's how she helped me. She did it. And it's awesome because we can talk about this case there. So please go to Facebook and follow this page there. We're just starting. So Bianca Meme on the YouTube chat group. That way you guys can give me ideas, respond to questions, and just interact as a community. And I love it so much. Scott says the defense went there in trial one. Karen Reed was framed. Oh, that was so strong. I love that opening statement by Yannetti. Here is how and why that didn't work this time. It's reasonable doubt beat over their heads. I agree. I think the reasonable doubt has to be the main factor. If you're sitting in the jury wondering, maybe this happened, maybe that happened, maybe that happened. If you're sitting in the jury without absolute certainty that a car could have hit him and produced no injuries, all of that, you have to just emphasize and re-emphasize all the reasonable doubt aspects of this case. Karen Reed acquitted on all charges. Wouldn't that be nice the day that we get to see this phrase? That would be awesome. Scott says, I am part of the structure of the FKR echo chamber. LOL. Right. Me too. But I at least admit I live in an echo chamber. Once in a while, I'll read the other comments from the other side, and I'm like, you guys are stupid. But I'm aware they exist, and that is important. Corina said, I just hope the defense explains reasonable doubt in their closing. Yes, we're together going to create a very good closing argument, and hopefully we're going to have some tips from what we would like to hear as a normal person sitting in the jury. After watching all this, I think it's valuable. It's valuable. Mark says, I can't get by the second Brian's getting rid of their phones, and why? Right. Do you think a younger jury is more likely to believe in police and government corruption? I don't know that. That I would have to do some research on. But I will start your question here and maybe go back to it later. DA Meatball Morrissey. Now you keep saying meatball. I kind of want to eat meatballs. Needs Karen Reed convicted of something. In that way, the true third-party culprits walk and the corrupt police look like they sort of did their jobs correctly. Karen is up against the entire corrupt system, the government, the district attorney, the DA, the judge, the prosecutor, the Massachusetts police, the Canton police. It's breathtaking. I'm just an echo of an echo. Right. So now we're going to take a look at the actual text messages. We did that the other day, but I found this slide, because I've heard some things, like I've seen some things on X, for example, and I was like, I don't recall that being in his text message exactly. So I want to see what was actually in his text messages. And I have circled in red what are the most damning ones. So for example, these are the whole text messages, right? That's like 16 hours into the investigation. So the officer John O'Keefe had just died, and he's texting with his friends saying, I'm sure. So his friends like, Bird, I'm sure the owner of the house will receive some shit. And Michael Proctor's like, nope, homeowner is a Boston cop too. That shows a lot of bias, right? That shows, listen, jury, if you're just a member of the jury and there was a dead body in your lawn, you can bet your bottom dollar that we would be asking you questions, arresting you, doing all kinds of things, going into your house without permission. We would do all kinds of things. But this is a Boston cop we're talking about, and we don't treat them the same way. So that is a bad text message for Proctor. So I would say, read that. Then what did you say? Then what did I say? Then what did you say? Guys, the more you talk about meatballs, I want like spaghetti meatballs, like from a real Italian. Real Italian. Haha, think about spaghetti meatballs for dinner. See, Scott, you're reading my mind. I don't want to think about the Morrissey meatball. I just want to talk about a delicious Italian dish meatball. So here's another one. When somebody asked him, I thought he was drunk. Did he get beat up? So again, 16 hours into the investigation, no me, no death determination, and Proctor's like, no, he didn't get beat up. How do you know? What is your investigation based on, sir? Okay, let's see what else in his text messages were most damning, in my opinion. When he's responding to this, oh, gotcha, he was frozen in the driveway and she didn't see him. And he's like, that's another animal we won't be able to prove. So here's the lead investigator saying, we won't be able to prove. Okay. So if you're the lead investigator and you're saying up front, you won't be able to prove, how can you ask the jury to convict somebody beyond a reasonable doubt? And then we also have here towards the bottom, I assume you guys are out to make it cut and dry because it involves cops, right? Somebody else says, something stinks. And then Michael was like, yeah, but there will be some serious charges brought on the girl. And I don't think this is showing him being biased. This text message specifically, I think he's just saying, I think she did it. That's his only viewpoint. And there will be some serious charges because of what she did. I think that's what he's saying. Now, where he says there will be no heat brought into Brian Albert because he's a cop too, that is classic bias to me. So I try to be fair. Let's see the next one. Okay. So the next one, that's, those are the really bad ones. From all accounts, he didn't do anything wrong. She's a beep, beep, beep. Yes, she's a babe with a weird Fall River accent, though. No ass. 0 chance she skates. She's effed. So those are bad for him to read on the stand. Now with his sister, and I think we're missing some of his sisters here, but he's saying all the powers that be. Oh, this is with his. No, this is with his school friends. All the powers that be want answers ASAP. Then we have 3 days after the death. Nutbag, as chief would say it. So that shows the culture in the police department, right? The chief calls defendants nutbags. So that there's no problem with him calling her that. And then talking about her leaky balloon knots. Okay. So here are all the other chats. My first girlfriend was Italian dish. That's Glen Lake saying. Glen Lake. Always funny. Oh, wait. I skipped one. So here is Michael Proctor to his police group chat, including his supervisor. Funny. I'm going through his retarded client's phone. No nude so far. I hate this man. I truly hate this man. Then we have rookie move. Then somebody else, look at this, okay? David the Chico is saying, rookie move not meeting with the medical examiner and getting that homicide determination. And then Michael says, Yuri and I had 2 conference calls with her, had numerous photos, etc. We laid out the entire case for her. So here is the lead investigator saying, we told her the case. We told her everything. Okay. All right. That's fine. And then somebody else said, no, then Michael, so DD, David the Chico says, should have had me or Jeff do it. Michael Proctor answers, if you two did it, she would have made it accidental or natural causes. Of course, it's undetermined. She's a whack job. So he's calling the medical examiner a whack job. Okay, so it just shows the culture and how he feels about these women. And that is a good thing to show the jury by his own words. Okay, so this is just the thumbnail from the video from last year. If you guys didn't watch Michael Proctor's full testimony, that is a video of his body language of last year. But I want to just quickly go back to where we were with this video. If I could figure out where we were with this video, let me just see. And that is just the end of Michael Proctor and how he was testifying there. Okay, let me try from here, from StreamYard. See which parts face glitch. I think we remember that. Sidebar, what if anything shoe? We saw that. Looks at someone to his right. We saw that. Oh yeah, I think it was right around 9 minutes. 9 minutes. Okay. So let's play the rest of this Proctor video to see his demeanor and why we think that would be good for the jury to witness.
Avenue are you aware of depicting the defendant's tail?
Canton Police Department went to conduct a well-being check in on the dash cruiser camera. You can see the back of Miss Reed's vehicle and the right taillight to be broken and missing pieces.
You admitted in your own words that the cop homeowner wasn't going to, quote, catch any shit, right?
Correct.
Because you were out to quote, make this cut and dry. Isn't that right?
The homeowner wasn't going to catch any shit because Mr. Albert had nothing to do with Mr. O'Keefe's death.
Because you were going to make sure that the case was cut and dry. Those were your words, right? On January 29th at 2:22 a.m., there was a call between him and Brian Albert that morning?
I was not aware of that.
How many murder cases in the history of your career have you worked on in which the medical examiner made the determination that the manner of death could not be determined?
Objection.
I'm going to allow that.
I wouldn't feel comfortable putting a number on it. It's not a lot. I couldn't ballpark it for you, but I know it's not a lot.
Well, Trooper Proctor, you were asked this exact question in February of 2024 at another proceeding.
Mm-hmm.
And you indicated that you had never seen it in your entire career, correct?
I'm trying to run it.
Well, you were asked the question, so first, what do you mean by, of course it's undetermined? And your answer was, I said it at the time, it was kind of like, not like figuratively, of course, and of course, like I had never really seen that before in a homicide, end quote. Correct?
Yes. Observed those injuries at the hospital, the one sneaker. Later on in the day, the CERT team, along with Detective Lieutenant Tully, found broken taillight pieces that matched Miss Reed's taillight, as well as the missing sneaker that matched Mr. O'Keefe's vehicle. Some inconsistent statements that Miss Reed had provided to Sergeant Mechanic and I.
So at the time that you made those,
So this part right now is just to show you guys what he would be like, right? What he would say, because this is his story and he's going to come and testify. Okay, this is what the evidence was. Let's say in the cross-examination, for example, because if the defense just decides to ask him about the text messages and the firing, okay, and just keeps it very short and concise, the cross-examination is limited. But we never know what Judge Bev is going to do. So let's say Judge Bev allows him to say, so what happened? How did you charge Karen Reed? What was the evidence? This is what he would sound like. And that's why I wanted to show you this, because even after he explains how he came up with that charge, he's like, well, we found this, we found that. And he's like, yeah, like he's just tired of his own story. And it just doesn't seem somebody like confident, about the evidence being provided.
comments, disparaging comments in regard to Ms. Reed in the context of those communications with your friends.
See,
As
Kelly was like
inexcusable, as
convincing.
unprofessional as those
Wow.
comments are. The information that you had was that Ms. Reed had struck Mr. O'Keefe with her vehicle.
Yeah, you've got to watch the form, Mr. Louder, it's sustained.
The time that you made those inexcusable and unprofessional comments, what did you believe the defendant had done to Mr. O'Keefe?
I believe, based on all the physical evidence and facts, Mr. O'Keefe got out of that vehicle holding that cocktail glass he walked out of the waterfall bar with. Ms. Reed pulled ahead and then backed into him, struck him with her vehicle, and then left.
Then came back 5.5 hours later, correct?
Correct.
Shame on you, sir. Shame on you, sir. Shame on you, sir.
That was classic. That was so good. Shame on you, sir. Oh, I loved it. I loved it. I mean, I know this is a real case with real lives on the line, but I cannot help to be entertained with this case. Ask Bob says that this Proctor text chat was too easy and normal to be a one-off. Imagine if you could see other state police's phone. Proctor is now the patsy of the state police. They have to silence him now. Right. I think they just were like, all right, that's a loss. You are being thrown to the wolves. Good luck to you, sir. Deb's main cuts. I love it when AJ cusses. Yeah, but if it was Brennan, we would be pretty pissed, right? Because we don't like Brennan. We don't like Brennan. Okay, let's see. Logical Observer says, yes. Oh, they got to bring him on, but I hope it's in prosecution's rebuttal. Kelly Cal says, I stopped watching reality TV once I started following Karen Reed. LOL. Right. I go to like sometimes I'm like, all right, I need a break. My brain needs to like distance, and I'm like, okay, Netflix, nothing there. Nothing. It's just hard to find something entertaining. And then I'm like, okay, let's go back to the trial. Let me just watch this so-and-so testimony now. So-and-so testimony. So yes, we're almost done. Okay. We're going to do this 2-hour marathon. We're going to try to do this every Sunday because I want to make it more consistent because I'm not consistent at all. And the next thing I'm working on is this mock closing argument. So what I did is I asked you guys on Twitter and also on Facebook, this group, wonderful group, that I ask you to please go there and join so we can have like a community grow. Okay, Bianca MM on YouTube chat group that is created by Karina, my wonderful, wonderful friend Karina. And on X, I asked for what are some of the key, let me see here. What are some of the key points that you would make if you were the defense team? And here are some of your responses that I will definitely take as suggestions. Okay. And we're going to go over a few of them now and then discuss what has been introduced or not. So if you guys have any ideas in the chat, feel free to write them down. So here I have Dr. Ranchler Sandwich said, Christina Hanley, MSP Crime Lab, no DNA or blood on tail light pieces, and Dr. Scoribello, ME, Was told that Karen Reed said I hit him, and did this not change her opinion? Visual of tail eyepiece that MP found the day after you researched 34. Okay. So from this, what I would take, okay, I am definitely going to have a key point, like a bullet point called the medical examiner testimony. And I would include all of the, well, I would include in try to summarize to the best of my ability, okay, that the witness, the prosecution called, the medical examiner, their own witness testified. She could not determine this was a car collision. The injuries were not consistent with a car collision, and she had doubts about the cause. How can we not have doubts when the own? Well, this is a bad rhetoric right now, but I will put that in writing, and it's going to be better. Another example, the Commonwealth did not and cannot prove a collusion happened. Emphasize all the things that they failed to do. They didn't investigate other possible culprits. They didn't search the house. They didn't secure the scene, photograph the car. Hammer reasonable doubts. And that's what you guys are saying today as well in the chat. Hammer reasonable doubts. What they didn't do. Right. I would like to keep the closing argument very simple. Like, yes, you could throw some of the factual, science portions in there, but I would try to hammer this type of argument. How often do you see in an investigation when a body's found in somebody's house that nobody's questioned? The house is not searched. The telephones are not. The only person they asked was the only person who was not involved with the police department of that town. So that would be a big, big part of the argument. So Kelly Cow says, LOL, I have been looking for you on the weekend, so you are missed when you're not on. Thank you so much. It makes me happy. Sometimes I'm just not motivated. I'm like, oh man, I don't know. I don't know when I go live. Sometimes there's nobody. But I'm getting a little better because Karina is always motivating me. And I think that I'm aware that I'm not consistent and I have to be more consistent so that people know, oh, she's live there. And if they want to come, they can come. But if I'm just live whenever, how are people going to know? But thank you. I appreciate that. Queen Olive says, I'm switching to my phone to run to the store, but I'm still listening. Hi, Queen Olive. Are you going to pick up some meatballs today and spaghetti? Okay. So let's see another key point that some of our wonderful people from X are giving us. Jennifer just says there was no collusion. There was no collusion. And they're going to hammer on this. I know because that's their favorite. Oh, thank you, Barbie. Thank you so much for gifting 5 memberships. Yay. Love it. Thank you so much. I appreciate that a lot. Leanne, so sorry, not sorry. You look really well, Bianca. I love seeing your smiling face. Thank you. And I love having you guys here. ProHack says, I just joined. Thank you, Karina. Facebook group, Bianca MMM chat group. So there was no collusion. And I think the defense is going to hammer that. I just would suggest make it as simple as possible. Make it as simple as possible. Because that is what the prosecution is doing. They're they're ignoring a lot of the data. They're ignoring a lot of the facts. They're not hammering on a lot of it. They're like, okay, these are the videos. You see, she said I hit him. We have this, we have that. And obviously, she's guilty. That's what the prosecution is doing. And I sometimes get lost with all the technical information. That's just me. I know a lot of people are probably younger, smarter. Maybe they're engineers in the jury. Great. But for me to understand what they were even trying to say with all the experts' testimony last week, I had to watch and rewatch and pause and read the PowerPoints and then have somebody else explain during commentary. And then just yesterday, I was like, oh, I think I get what they're saying. Okay. So when the car turns on, that's a key cycle. And then it's immediate. It happens immediately in the Lexus for the Sogra. The other two are thinking there's a 3-second delay. Got it. But then I'm still like, okay, what does one thing have to do with another? It wasn't easy for me to understand. Somebody else said, proud patriot mom. She said, not one piece of taillight was discovered until Karen Reed's car was in the Canton Sally ports. I don't know about that. I think the CERT team did find fragments of taillight, and what we have is a miscommunication of the time. If there was enough time for them to plan something between the time the SUV got to the Canton Sally ports and the time the CERT team was there, because the CERT team did find a shoe and some fragments of taillight and something else, I believe. So that's the team that actually did a methodical search. And then everything else, yes, 47 pieces of taillight and all the other stuff was found afterwards. So there is a little bit of question here. Somebody else said ME, not hit by the car. And then Logical Observer on X and on the chat. Thank you. And the prosecution never called their lead investigator. Yes, I would definitely add that to the closing arguments. Tina says, according to prosecution experts, Karen went back 50 plus feet. She would have hit Higgins' Jeep. Also, Ryan Eagle clearly states Karen was alone in her vehicle. So where was John? Yes. So with that, I would just put everything together in one bullet point. Like, we had a plow driver drive with a flashlight, from high up, because he has to make sure there's no animals, nothing. He inspected the snow before and after, and he did not see a body. We had Ryan Eagle park right behind the SUV during the time they are claiming this happened, and he didn't see John O'Keefe anywhere. Karen Reed was by herself in the SUV, consistent with her statement that she just waited outside. She got frustrated and left. She didn't reverse into anything. 80 feet, 50 plus feet, she would have reversed into the house, into the bushes, into the neighbor's house. How do they know? And if they cannot even tell you how this happened, because their own experts testified, we cannot confirm the points that the car would have been at, the starting points. If they don't know that, how can they claim they have proved to you beyond a reasonable doubt that this happened? There was no collusion. There was no collusion, right? So Barbie says, you're welcome, Bianca. I came in late and I am lurking in the background. Awesome. Well, go back to the beginning later, another day, because the beginning is interesting. Talking about the psychology of the jury and stuff. Logical Observer, yep, closing arguments that make the jury finish with more questions than answers. Here's some samples. I like that too. Here's some samples, explanations of what could have happened. Could John have gone into the house and got into a fight? I wouldn't be like, oh, they were like sparring around. And I would just be like, is it possible that John O'Keefe went into the house, got into a fight? Is it possible that John O'Keefe went into the house and got bit by the German Shepherd who was later rehomed? Is it possible that John O'Keefe fell into the gym equipment and hit his head inside the house? Is it possible that the cops did not want to get involved with the death and decided to say, let's just put him outside? Is it possible when Brian Albert didn't even go outside? How many things are possible that could have happened here? If you are still wondering in your mind what could have happened and how could this happen, this is normal, but it's also reasonable doubt. Barbie says, Gallagher's snowblower video says it all. Not one piece of taillight in that video. Okay, so the first people at the scene didn't find anything, right? Mark, taillight was found at 5:45. Car was at Sally Port at 5:35. Yeah, that's what I was talking about. Always something. This case always has something to keep you guessing. Logical Observer says, thank you for inviting me. You got a new subscriber. Thank you. I am so happy to hear that. I appreciate the support, really do. Scott says, fine, even if the times are messed up with. Who knows if the first few pieces of taillight were actually from her Lexus? Could have been any taillight fragments and unsecured scene with the unsecured scene all day. Correct. Unsecured or declared crime scene all day before the state police got there. Yes, and that is all logical. Remember what we said about logic today. That makes sense, okay? But we're focusing today on the emotional aspect of the jury. So then Amy says the definition of reasonable doubt and that the defense does not have to prove anything. It is solely up to the prosecution to prove guilt in a singular possibility, and that if the jurors see a couple of possibilities, then that means they legally must find her not guilty. Absolutely, yes. Absolutely, you have to make that point. Then Gina said, how did the tail light get on the lawn? Also, no blood, tissue, clothing fibers, dirt, salt, debris on the tail light. No dirt or debris, blood. No dirt or debris in John O'Keefe's head wound. Blood down the back and front of his shirt if he was laid flat, incapacitated. Right. And another thing interesting about that also is that the no tissue was found in the tail light. If they're saying he was, and also the experiment, the Blue Man experiment, the guy was like literally holding his arm like this, Dr. Welcher, and then he rotated. He said, "Oh, the car forced me to rotate." I'm like, that's not even a real experiment. If you're an accident reconstructionist, let's reconstruct what you're claiming. You're claiming she went 50 plus feet reverse at 24 miles per hour. Let's see that. And if you don't want to be the dummy this time, get an actual dummy and let's see the damage that it does. But you know why they didn't do that? He said it himself. He said, if we had done those tests, I would have to sit here and explain to you during cross-examination why it was different. He said that. So I'm going to work on the closing arguments. I have a lot of work to do. Just for funsies. But I want to read your last comments here because I am loving the interaction. Logical observer, yes, I agree. Keep it simple. Yes, keep it simple. Keep it simple. Let me see. Queen Olive, the defense needs to pound reasonable doubt. Scott says, haha, I am great at going off topic, my specialty. All right, so that's it. So this is where we're going to end today. Okay, guys, tomorrow we have courts. Are you excited or what? Who do you think the defense is going to call tomorrow? I'm excited. I'm also going to dog sit. I'm going to be babysitting, I like to say, 2 extra dogs this week on Tuesday through Friday. So I'm probably gonna like have a show or something just to show you guys. 2 Cavapoos. They're so cute. One is Teddy, the other is Lexi, and then I have Whisper as well. So I'm gonna have 3 little dogs in my house. So I don't even know what I'm gonna do with myself. I'm just gonna lay there, watch Karen read, and have dog parties all day, every day. But thank you so much. I hope you enjoyed this content. I hope that it can bring some light, to the other side of the haters, the other side, the people that are trying to do guilty. Why I think that bringing that emotional aspect for the jury to identify and put face to fact, Michael Proctor's face to his text, Brian Higgins' face to his actions. I think that is so important. Also, Brian Alberts, I would keep all of those direct examinations as short as possible. What did you do in the morning? Who notified you of the death? What did you do next? Oh, I stay home. Okay. You didn't go, I would try to do the direct examination to the best of my ability to bring the facts I want, keep it very short and simple so that the prosecution doesn't have a lot to go with in the cross, knowing that the judge is going to allow the prosecution to do a lot that we don't like. So, Barbie's always asking, where's Whisper? He's in the balcony. I feel so bad because it's raining all day. We haven't gone out. I just went to church and that's it. But I will try to entertain him a little bit now. Mark says, thank you so much. Thank you so very much. Love and hugs from Lady Lake, Florida. Thank you. Excited, looking forward to your mock defense arguments. Yes, I'm excited too. So guys, enjoy your Sunday. Have a great day, great rest of the day. I'll see you next time and love you so much. Thank you for watching, guys. Bianca MMM, your go-to place for mind meditation and motivation to elevate your life and keep you entertained. I'm passionate about exploring the human mind and psychology,
And here, we dive into court proceedings, body language analysis, and sprinkle in a bit of humor along the way. You will also find content to boost your personal growth physically and mentally, featuring quick meditation techniques and uplifting messages to kickstart your day. Your support means the world to me. Until next time, take care and stay positive.